Let's welcome everybody. And before we begin, I want to acknowledge the Narrabindi people as the traditional owners upon the land upon which we meet, and we pay our respects to the elders past, present and emerging, to all Aboriginal elders from communities who may be in attendance today. ACS also supports diversity and inclusion in all types. Diversity and inclusion are important to the ACS as we represent a diverse of membership and backgrounds. Good evening even, and welcome to tonight's event. My name is Joel Harris. I am the Tasmanian branch and chair for ACS in Tasmania, and have a special interest in tonight's topic, as well as I'm also a CEO of an MSP, that is someone who delivers managed service provider, who delivers services relevant to the topics on today. Tonight's program is now on your screen, I hope. Just looking, want to confirm. Thank you. Is now on your screen with the main speaker, John Moran. I look forward to having a deeper understanding of how we can, as tech professionals and innovators and business managers, use service agreements to successfully navigate and increasingly hot digital data and privacy environment in which we're working now. I also note that tonight's presentation and content relates only to Australian law. So if you are coming in from somewhere else, please be mindful of that. At the end, we'll also have a follow-on from John's presentation with a Q&A where we'll have a few people answering questions, myself included. When we approach the audience Q&A component, please use the Q&A box on the sidebar on the right-hand side of your screen. Take this opportunity to ask as many questions as you have. We will try our best to get through as many as possible while we are online. Before we get going on to our main game for tonight, a couple of starters for us. We'll be doing about 4 polls through the evening, so please take a few moments to get this webinar link up on your phones. Just get confirmation that that's up. Great, thank you. Tonight's masterclass is focused Tonight's masterclass is focused primarily on areas of work provided by our tech professionals. Please go back to your phone after answering the first question and follow on. You should see another additional question coming through. Not sure if those questions are also meant to be on the screen, but that's all right. If you can use the QR code though to get through to where the questions are asked, that'll enable you to see those questions and answer. Now we're on to tonight's main game. We're delighted to welcome John Moran as our speaker. John is the CEO of Atmos and leads 3 operations teams in its readiness, its directors and officers, and disputes and investigations team. John has an extensive experience in handling some of the largest and most complex data, privacy and digital breaches. He focuses on sharing his knowledge of what makes data and cyber incidents severe for business and helping clients map their readiness journey. John is a market leader in organising organisations and guiding them on how to improve their incident response by enhancing crisis management teams, performance through a range of Atmos services and products. John is also an industry-recognised litigation expert in the specialised area of disputes and investigations linked to cyber, privacy and data for both corporates and their directors and officers. We're delighted to have John join us this evening and look forward to having a much better understanding of the cyber, data and digital risk environment in which many small and medium managed service providers are operating. As a lead-off, John will cover the content of tonight's masterclass. Thank you, John.
Excellent, Joel. Thank you so much for the very warm welcome. We're absolutely thrilled to be partnering with ACS today. So a big thank you to the entire team for all the prep that's gone into today and getting ourselves ready to make sure that the content is on point. It's going to be short, it's going to be sharp. So you're going to have to buckle in because I've been given a very tight slot of 15 minutes to cover a whole heap of ground. We're going to move on to the next slide and get my mug off this slide. But I just wanted to say, I'm going to cover a couple of things today. We're going to talk a little bit about some things old. We're going to talk about some things new, but most importantly, what I'm going to try and do is take you through a whole range of practical things that are helpful to you for coming away from today. So in some of the content I'm going to talk about, you might think it's basic, you might think it's 101, but why it is important is because the fundamentals, the 101, the very reason that we're having this masterclass is they're the things that unfortunately cause pain to our tech clients in terms of the issues that crop up later down the line with clients, the problems that they have with clients when things go wrong. So what we're going to moving on to the next slide, the one after. It's great. Thanks, Chris. Great. So we're going to cover a couple of different things today. We're going to kick off by talking about key service agreement terms. So what we're going to do is, how do you set those agreements? How do you navigate them? How do you negotiate them? We're going to give you some top tips on potential business exposures. So the types of things that are cropping up in these agreements, that are cropping up in disputes, that are causing the tech providers pain with their clients. And then most importantly, how can you mitigate them? And we're going to give a special shout out to the ACS professional standards scheme. So a really important backdrop that's available to all members there to try and protect your business when you are contracting with clients. We're going to talk it through some mechanisms for trying to resolve disputes. So what's the best and most efficient way to get to the end of the journey with the client, to bring that to resolution and to close it. And then across the course of the questions as well, we're going to pick up and do a bit of deeper dive on some hot topics that I know everyone will be particularly interested to hear about in terms of consumer law, misleading, deceptive conduct, and give you some practical examples of what we're seeing land on our desk and what we're helping clients navigate through. So without further ado, we're going to move on to the next slide and talk a little bit about negotiating a contract. So I've tried to make this super simple. I could talk about a whole heap of things, and for anyone who's ever heard me speak before, you know I can talk. Boy, can I talk, and boy, will I go for a long time. So I'm going to promise to keep it really short. We're going to talk about three things. We're going to talk about setting the scope. We're going to be talking about doing advanced thinking and planning for that moment that you hope never happens, which is termination of a contract. And then we're going to talk about a really hot topic, something that is really, really painful for clients and can often be underestimated. So what I wanted to talk about was, and forgive me, this might seem boring, this might seem 101, but I'm going to tell you why this is really important. First of all, getting the scope and getting the service description right in the contract. We all know why it's important, but to recap for anyone who doesn't, it ensures that you get paid for the right amount for the right amount of work. It locks in expectations, and most importantly, it's there as a barrier or a metric to monitor scope creep. Scope creep is the biggest killer for our clients that we support. Expectations are misaligned. The expectation of the service delivery, when it will be delivered, how it will be delivered. If expectations are not managed implicitly from the outset and during the course of the contract, it's almost a highway to having an issue, a fast track way of having an issue with your client. The contract, it also acts as a really helpful benchmark throughout the life of the relationship, because ultimately that's what a contract is. It's a papering of the relationship with your client. And that benchmarking allows you to bring the client back to reference the things that you've agreed, and also to kind of use it as a prompt for a conversation throughout the life of the agreement. And obviously it goes without saying, investing time in procurement upfront. As painful as it might be, nobody loves procurement. It is there as a safety net. It's a safety net for you. It's a safety net for the customer. And I promise you that if you get it right and you invest in it up front, it is going to save you weeks and months of back and forth later down the line. So on the scope, what should you lock in? Firstly, what? So specifically, what are the services that you're providing? Everything you'll do. Most importantly, what are you not doing? What's not included? When? The start date for the project, anticipated timelines, duration of the project, how payments will be made. How? Setting out the process. So what are the things that will be delivered? When will you be able to deliver? Are there contingencies on the deliver? Are there service requirements or service providers that need to form part of the contract? Are there deliverables from the client themselves that you require on? And most importantly, who? So who is going to be responsible for different components of the obligations? We were having a quick chat earlier on, and Joe made a great comment, and Lisa as well, around what is the expectation, who is the owner, or where is the overarching onus around, let's say, cybersecurity, around data handling, around regulatory compliance. A contract doesn't kind of shift all onus and responsibilities. The idea is it will shift what you say it shifts in the contract. So you need to be very, very clear around the what, the when, the how, and the who. Also, in terms of setting the scope, I think everybody in this room knows this, and I'm probably saying a very captain obvious statement, but making sure that you very clearly map out exclusions. When work is outside of scope, make sure that it's documented, make sure that you are capturing how those additional services will be charged. And I'm going to come back to talking about why that's really important in a contract in a couple of minutes' time. Let's move on to talk about termination. First thing I'll say is people don't like to think about this. People don't like to think about it because it typically reflects maybe somebody's done something wrong, or a contract is coming to an end, or the unthinkable has happened. But we really want our clients, we're there with our clients to support and encourage an open dialogue between both parties when they're negotiating the contract, to do the deep thinking on it, because both parties will benefit from a really well thought out and detailed termination clause. It doesn't mean that you have to spend a lot of money on it. It doesn't mean that it has to be like the best drafted thing in the world, but it does mean that if it captures both the parties' thoughts early on, it's going to make for a smoother off-ramp at the end. A good termination clause, what will be in it? Well, firstly, the rights to terminate for both parties. So as I said, it should capture the minds of both of the contracting entities. It should set out a number of different routes for termination, so specifically what they are. And then it should set out what the threshold requirements are. So is it time? Is there a capability to remedy it? What they are and specifically what you both have in mind. Most importantly, what, if anything, do you get paid on the termination event? How is this framed? Is it by reference to exit costs? Does it include profit or loss? Does it include consequential loss? These terms, we all become a little bit glazed over when we look at these terms in a contract, but people who have been in this really painful point at the end of a contract or at the end of a relationship with a client who have had to rely upon these will understand the significance of those clauses and what they mean, particularly in terms of revenue and margin for what might be, at an abrupt end to a contract with a lot of fees outstanding or work done that hasn't been paid for. And most importantly, make sure that you're entitled, what you're entitled to at the termination reflects the investment in the relationship. So termination isn't just about bringing the relationship to an end and everybody sailing off into the distance. We recognize that what you do, the services that you provide, it'll typically involve a lot of upfront work. So you might have front-loaded your relationship with the client. You might have invested really heavily upfront in the contract, put a lot of time, effort, and cost into onboarding, bringing them on, setting it up, putting all the structures in place. That might be your biggest loss. And if the relationship is terminated shortly or halfway through a contract, that for you can result in a significant hit to the balance sheet. So again, just starting to map out those costs, map out the contract value, map out the delivery as against the termination provision. So you have a bit of better understanding as to where in the pain point of the journey from a termination perspective you might want to sit. We've just come off helping an MSP client who had a very valued client relationship. The relationship didn't break up for anything bad that had happened, but that client had invested probably 80% of the contract value into the first year of a 3-year contract. So that was remediating, getting the client up and running, and they got the client to an amazing place where they were up and running, really happy with the service. The contract had to be terminated, but they were only entitled to a small proportion of the work that they had undertaken. And unfortunately, the contracts in the clause had not been set out in a way that captured for that. Not because there was laziness or not because people hadn't focused their mind, but just because nobody thought that the unthinkable was going to happen. And unfortunately, that's really, at the end of the day, the contract was what the contract was. And there was no way to support that client in negotiating their way around it, other than doing what we managed to do, which is approaching the client and having a detailed conversation around the work that was being undertaken. So just being, very practical around these things, both in terms of when you're crafting the contract, but also when termination comes about. I'm going to move on to something that I'm very passionate about, which Joel and Lisa might have to kind of mute me in a second if I go and speak for more than like 60 seconds on this. But Atmos, a little bit around who we are and what we do. We're focused on privacy, technology, digital risk. We help clients with technology issues. We help them with privacy issues. We help them with cyber issues. But a big component of our business is helping organizations respond to data breaches and security incidents. So helping MSPs, helping their clients, whoever we might be supporting. As I was telling the team earlier on, we're really busy. We do more of this than anyone else in the market, but we're also seeing a massive uptick in the level of incidents that are occurring. First party breaches, second, third, fourth, fifth party, a whole range of different types of incidents, a lot more severe than we've ever seen. I think there is, in fact, more ransomware in the Australian market at the moment than I think I've ever seen in the 12 years I've been doing this. But why I wanted to flag this is not to take you off on a cyber tangent, but really what I just wanted to say was the cost for a technology provider in managing a breach that impacts you and then impacts your downstream clients can be and will be significant. There's a load of different statistics and figures that you're going to be able to pluck around the average cost of a breach linked to a record. That can often be misleading and really, really difficult. But I can tell you this, a third might affect you and affect your clients. On average, it costs 20% more than if the breach was just hitting one entity. So in other words, you're up for your costs for managing it. You're also potentially up for the costs of all the other entities that are impacted. And what we're seeing is that, again, nobody wants to talk about this up front in the negotiation, but it is a really, really critical component of risk and exposure for an organization if the contract doesn't anticipate it. So really what we want you to do is when you're contracting with an entity, start thinking about what a data breach for that organization might look like. So what is it the organization that you're supporting? What is their risk profile? What are the types of clients that they support? What's the industry they're in? What's the data they hold? Because in risk analyzing that target, you're going to have a better understanding of how your exposure is linked to their exposure. Now, you might provide different types of services. This might not be relevant to everybody, but if there is a world where you are actively monitoring their perimeter, if you're actively involved in the running of their infrastructure, and if they, in their mind, see you as kind of the linchpin on protecting them against incidents, and an incident occurs, it's very frequent that a client will kind of come back to talk to their MSP or talk to their technology provider around how the technology that they provided or the services they provided or the products they provided might have caused or been linked to the loss that they suffered. So what's really, really important here is, first of all, having an open conversation around the insurance requirements. What insurance do they hold? What insurance do you hold? What are the obligations for the parties to work together in the event of a data breach? But most importantly, who's carrying the heavy lifting work streams of the incident response? Is it you? Is it them? Is it both of you together? That type of kind of discussion and collaboration. I know it might seem awkward to have that conversation up front because, again, you're talking about the unthinkable. But if you can start mapping that out with clients, you're better prepared to understand the risk profile. You're better prepared to profile and scope the contract and to kind of risk weight the agreement, because these breaches are happening. We're seeing a huge amount, and particularly the SME sector, there is a massive amount of breaches happening there that just don't make the paper and don't make the media. The big incidents always do. They're always front page, second page, third page. But what's not making it is just the sheer volume of mailbox breaches, business email compromise, third-party vendor breaches that are impacting Australian organizations and the technology providers that they support every day of the week. I think I've said enough on that. I'll keep going, but I might get you to keep moving, Chris, onto the next slide. So I wanted to talk a little bit about practical tips. I'm going to keep this really short because, again, there's so much that I could say around this. The first thing I wanted to say was, firstly, I recognize that sometimes negotiating these contracts, there may be no room to move. But that doesn't mean that the negotiation or the discussion with the client isn't going to happen. So what we say to clients is, first of all, try to shortlist your list of issues. Have your list of do or dies, have your list of clauses and topics that you've got a bit of wriggle room on, and then have your list of things that, like, I suppose realistically, like, you're prepared to give or you're prepared to take. Try and avoid going into contract negotiations with a long list. People often think that it is better to go in with a long list and then you're going to start trading. The worst place that you can find yourself is where you're trading one give for a take or one take for a give. Because what you will typically find is that that short list will start reducing. You will have given away things that maybe seem innocuous or seem non-problematic, but might in fact be problematic. And then you're left with a shorter list of points that you're essentially just horse trading on. You're giving one to take one. What we want clients to be able to do is just to be able to articulate why that clause is important to you, what that means for your business, what that means for your contract, and what it means for the client. Because typically most clients, if you can approach them with a kind of a sensible conversation around why the limitation cap is problematic, why the exclusions are in place, why the certain carve-outs are required, they will typically get it. They will understand it. Now, listen, I'm sure there's some on the calls who are saying we've been through procurement and a lot of clients just don't get it and they just want to have a hard negotiation. I don't doubt that. I absolutely understand that. But really what we're trying to say is get to the crux of the negotiation quicker, because the longer the negotiation goes, it's when the fatigue kicks in at the end, and it's when people just give, and they typically end up giving on clauses that potentially mean the most. So really try and limit the issues and get to the issues as quickly as you possibly can. And the last thing I'd say is, with your contracts, a really useful exercise, and I know this is not going to fill your heart with joy or make you want to jump out of bed in the morning to do it, but if you can sit down with your contract, print it out, have it in front of you, and look at it and say, what of these clauses actually would cause us pain and would cause impact to our balance sheet? If you can start to translate what the clauses mean in terms of impact to your balance sheet, you'll have a better understanding of when things go wrong, how it's going to impact service delivery, how it's going to impact your margin, how it's going to impact the client relationship. If you can put a price point on these clauses or get somebody to explain to you what the exposures are in that more practical term, it allows you to have a more holistic view to the agreement. It will probably incentivize you to probably turn away some work, to realize that there's just potentially too much work, there's too much risk in it. It will allow you to hunt better work. It will allow you to kind of negotiate better terms or contracts with clients, and also to have kind of a more open and honest conversation with clients around where the risk sits for them, but most importantly, where the risk sits for you. And then I might move on to our next slide, which is liability on the lease. So I just wanted to kind of talk through a couple of different things around exposures and how to try and keep them in check. So firstly, the three most common methods of doing that. We see that quite frequently when we're brought in a dispute. Actually, I'm going to take a back step from this. I'm going to use, again, I'm sorry to bring up cyber one more time. I promised I wouldn't do it, but I'm doing it. What we try to do at Atmos is we want to try and get clients to think about when they're at their best in their business. And what I would say with the tech industry, having worked with a whole heap of different technology providers, you're typically great when there's a crisis. You are typically kind of plugged in to know when things are going wrong, how you jump on it, how you service it. But that kind of incident response mindset that we see in cyber incidents, that we see businesses, doing their absolute best or like performing at their absolute best day, they typically don't display those skills or those tactics when there's a problem with a client, when there's a complaint with a client, when there's a hard conversation. Naturally, sometimes people pull back or they lean in too hard into the problem. And what our whole ethos is at Atmos is trying to apply an incident response mindset to problems in a contract. So really what we're trying to say is when the problem crops up, don't shy away from it. Don't lean into it too hard, but try and kind of apply that methodology that is probably inherent in a lot of what you do to kind of fixing a problem and getting a client through it. Try and kind of apply that crisis management, that emergency management mindset to trying to solve the problem for the clients. Because typically when you do, you're able to have that open conversation. You're able to guide a client through it in a lot quicker. I'm conscious that I'm coming up on time, so I'm just going to say a couple of really quick things on this. Good ways of negotiating problems, like effective use of service levels and service level credits. As I said earlier on, limiting and excluding liability for big potential exposures. So understanding the dollar value of those and being very careful about how you use those in the negotiation. And essentially just making sure that the insurance isn't just a thing or a tick box. So understanding your insurance, understanding the client's insurance, and using that risk transfer solution to better indemnify both the client, and the services that you are providing. I think you're all pretty familiar with limitation of liability clauses and the caps. What I would say on that is be really familiar with them. Understand the precise language of the agreement. Sometimes people just think the standard clause is it, and it's either in or it's out. But there's ways that you can adapt and manipulate liability clauses for your benefit or to give a client the benefit of something else. So is it one total cap? Is it a cap per event? Is it an aggregate cap? Is it a cap for the contract value? What are the business critical risks? Are confidentiality breaches, IP infringements, are data losses? Are they in the cap? Are they outside of the cap? Outside of the cap. A well-drafted cap isn't just about the number; it's about the kind of the risk allocation of the components in that cap. So try and get familiar with every word in that clause, every sentence in that clause, and understand how to deploy that clause to fit the risk that you're trying to either block out or to try and capture. One other thing I wanted to say is just also bear in mind upstream and downstream risk. So you might be providing a service to a client, but your services might be contingent on somebody else that's providing services. So if you rely on third-party vendors, make sure that their obligations are mirrored into the contract, that you're backing them up, they're back to back, and essentially just making sure that you're not left with carrying the can for somebody else's poor performance or failure to perform. And then last but by no means least, just giving a bit of a shout out as well to unfair contract terms. I'm going to come on to it in a couple of seconds, but for SME providers dealing with small businesses, this is tricky. You got to navigate this really carefully. It's coming up time and time and time again with clients to say that certain things are in, certain things are out. It's really tricky. There's some great guidance out there, and I know that the ACS has been through this and talked you through it before, and there's a whole lot of resources available to you. So again, just like keep it in focus, particularly when you're looking at businesses that have, smaller businesses, which we'll come on to in a second. I might jump on to the last slide, which I promised folks I'm nearly there. How to resolve. Most important thing is litigation is last resort. Apply that instant response mindset to solving your problem. That is what I would say. Lean into the problem. Have that discussion. Don't bury your head in it. What we say to clients is, first of all, negotiate in good faith. That kind of often will take a lot of the steam out of negotiation or out of an issue. Avoiding it typically only makes the issue worse every single time. You've got mechanisms in the contract. Both parties have agreed to determine how an issue will be resolved. So rely on the contract, but just also rely upon the basics. Rely upon human nature. Rely upon the good relationship that you had at one point in time. Rely upon the fact that you both had a common objective when you entered into that agreement. Mediation is a good route to solving things, but just bear in mind that you've got to have an exit from being trapped in the mediation circle or trapped in the ADR, because we've got clients who sometimes fall into that pipe and they never come out because they're in this revolving blender of it never ending. So you really need to make sure that there is a way for you to agitate this or to deal with it in a different forum if that's it. And most importantly, last things I'll say is de-escalate early. Resolve it efficiently and try where you can to protect that relationship. I've gone a little bit over time, so I'm going to stop talking, but I'm going to hand the mic back to Joel and to Lisa because I think there's some good questions going through. I hope everybody found that helpful. Just a little bit of a shout out as well that we've prepared a checklist for everybody that's going to be circulated after. It's going to be available. It's got these hot tips in there. I'm always happy to jump on a call. If you've ever got a problem, if you've got a question, ACS members, just call us. I'm really, really happy to lend a hand with that. But some amazing resources that are available to you through ACS. And again, just a shout out, the limitation cap through the professional standard scheme. It's a good protection. It is there for those scenarios that the unthinkable, that sometimes they're bigger than you might think they are. So Joel, back to you.
Thank you, John. That's amazing what we might have, but more importantly, now we know we didn't know before about how service contracts work and what drives the conditions under which it operates. It's time for our next poll. Just on the topic of Q&A though, keep the questions coming through on the side. We will cover them off when we get to the panel at the end, when John will be speaking on the panel. So keep the questions coming. For those, I just want to say, can we get the slide up with the question and QR code there? See if we can get that off. When that comes up, people please feel free to answer that question. Thank you. Around, do you work as a managed service provider, either as a standalone contractor or as an employee? And what size is your organisation? Look forward to hearing from you. We now have the chance to really gather intel from John in our first panel and then in our open Q&A. We're also pleased to have Lisa Zusak with us this evening, who's getting out and about with our members. Lisa is ACS Corporate Secretary and Head of Governance, Legal and Risk. She has more than 20 years experience as a legal professional. Using a pragmatic and commercially minded approach with a suite of postgrad qualifications, including GAICD, GIA, CIPPE, and advanced contract law. Lisa has a deep experience in contract negotiations and for managing risk within organisations. Lisa will lead the initial panel Q&A and then guide us through the questions in the open Q&A that follows. Welcome, Lisa.
Thanks, Joel. That's amazing for that introduction. I'm very pleased to present the next session. We have three initial questions to start our Q&A, and then, as Joel said, we'll then open to your questions. And we'll get about 5 minutes each total for these questions. So John, Joel and I will bring our perspectives to these questions. John on the service, contract terms and exposure. Joel as a SMP, and I will speak to sort of my in-house experience and from that approach. So the first one, if we can just go to the slide 15, please, I think, just in relation to the, I think there's, okay, I'm not sure where that's, anyway, so the first question is, how do consumer laws operate, including in relation to misleading and deceptive conduct? So, John, I'm going to hand it over to you, please, if you could just start from your perspective.
Yeah, I absolutely will. And you've all had the joy or the torture of listening to me for 30 minutes. So I'm going to keep this short because I'm actually more interested to hear what Joel and Lisa have to say as well. They've got a lot of hands-on experience. Not to reiterate what I've said before, but typically the seagull on a chip on this, the bit that you have to zone straight into is the exclusions and the liability caps. That's where this is stinging most under ACL. So I'm not going to school everybody on ACL. They understand what it's there to do, which is kind of essentially particularly focused on kind of unfair contract terms, but really you've done the work, you've worked out what it is, you've put in place a cap, you've locked down the service contract, you're comfortable with the exposure. But when things go wrong, what we're seeing is the lawyers on the other side or the client, they're essentially trying to kind of pivot this into saying that take it away typically from kind of the breach of contract terms and try and get it into the world of it being misleading and deceptive conduct. So what they might say is that the services or the promotional material or the information that you provided or the information on your website, that indicates that it sits outside, the liability will sit outside the cap. So a good example of that might be, for example, privacy breaches. So people might say that Privacy Act, you've got obligations under that. Every entity does under the Australian privacy principles to protect your data, to investigate when there's an issue. Typically, organizations will say that that might fall outside it, or there's a lot of uncertainty around the law at the moment as whether limitation law clauses apply to misleading deceptive conduct. You've also got, if it's kind of a small business, you're going to have like the UCT regime applying. That's kind of essentially on the front line, Lisa. That's kind of where we're seeing this kind of bite. Keen to get your views as well.
Yeah, thanks. That's great. Joel, tell us about your experience.
Yeah, look, building on from what John said there, we're the same. It comes down to statements around service capability. Particularly in cyber now, you know, with people saying statements around, hey, if you buy this, it's Essential 8 compliant, things like that. If you haven't got it vetted and, you know, a third party to justify that, don't say it. Quoting scope of works, definitions of all inclusive, fully managed, things like that, generic statements like that, just open for misinterpretation and risk. Cyber posture uplift. There's a lot of statements we've seen in the market around buy the firewall. You're fully, you know, protected now. Overarching statements like that. And the last one is that we see is vendor representations. You know, vendors are good at the sales brochures. MSPs have got to be so careful not to carry through the sales talk and instead make sure it gets down to specifics of what the actual product or service offering is about doing. And of course, the last thing coming over on this, which I know John's just been talking about, is there is an added element if you are selling into that small business or medium-sized business, just around consumer guarantees, conduct, and false and misleading representations, and value for money as well, and fair trading terms. It doesn't matter sometimes what your agreement says. There are overarching, protections in place for that group that you just have to be extra mindful of as well. Yeah.
Yeah, thanks. And I'm going to echo what you've both said. I think, making sure that the disclaimers are in place. As a lawyer, we love a disclaimer. And just also clarifying, the scope. So John's spoken about that quite a bit. Any assumptions is really important too. So any assumptions that you're relying upon, any dependencies, also should be captured in scope. The warranties, as Joel said, are really important, and the exclusion for warranties under the ACL. Obviously, you've got limitations on what you can exclude, but where you can, you try and limit your warranty scope too much. I guess you want to be obviously provide a service, but just be mindful of that. And something under the UCT regime that I see quite a bit that I push back on is things like auto renews. So that's becoming a big focus for a lot of contracts, and I dislike them from where I stand because they catch out a lot of businesses. So it is captured under the UCT regime. Same with termination rights. So just be careful, you might fall foul of those. And the other thing that's also important that I always look out for are payment terms. Your vendors are obviously going to, or your counterparty is obviously going to want to extend terms, and you're going to want to, for cash flow purposes, shorten them. So, you want to make sure that you're really capturing those and the milestones in your scopes as well. So when you're going to receive payment, making sure that's really clear. I'll move on to the next one. So just addressing other business critical risks, including confidentiality and privacy, and of course, IP and copyright, really important ones. Joel, I'm going to start with you. If just this question, where would managed service providers most be at risk in sort of some of these areas?
Thanks, Lisa. Look, we're going to start with customer credentials and data. MSPs are in a trusted position. We have access to so much of our clients' information and network and whatever, if IoT devices are connected and things like that. And so making sure that we've done all of the right things around that in protecting the information we have is critical. Then, of course, comes into some of the service offerings. We're responsible for the backups. We're responsible for the management and configuration of tenants. So there's service architecture documentation around how things are built and constructed and operated are also critically important. We find that the ensuring that, Australian privacy principles are built into a lot of the things that we do and things like that. So there's a lot of easy ways to make sure we're covering off some risk on those things. Within the IP space, though, while it is a risk, we find that most of the things that an MSP operating in a small to medium-sized business are generic. Where we, like transition in how to do deployments and things like that, they come from the vendors and Microsoft. Where we do get a bit of concern is probably where we're starting to build out automation, scripts, templates, or customization for helping clients with business continuity planning and things like that that might be specific for a client. That's where our IP clauses need to come in and just sort of draw a line in the sand on where we agree on those things, but also if we decide to not be together anymore, how we're going to disentangle those arrangements as well. There's something that we found not talking about that up front is how do we break up later on, and actually by talking about that, you actually strengthen the relationship.
Yeah, thanks. It's so important. John, let's talk about the law in relation to some of these issues.
Yeah. First thing I'm going to give is I've mentioned earlier on, but one thing I just want to plug that might not come up later on is your insurance, understanding your insurance. You didn't ask the question, Lisa, I'm going to say it anyway. Just getting familiarity with the insurance product that you bought, whether it's your tech liability product or your cyber product, because it is kind of tangential to the points I'm making here. you probably bought a policy that provides cover to navigate through these incidents and help you with these incidents that crop up. But my experience with tech clients is the insurance was just part of what you needed. It was your business operations. You did it, you got it in place. But what it's in fact got is it's got access to vendors like us who are there to support you, but it's also got a lot of other things that have been thrown into these policies to make them more competitive and make them more advantageous. So there's typically a hotline for free services, which that's what we do. You can call us and you can kind of like get some quick tips on how to navigate this. There's a lot of great resources, like great resources available through ACS. There's a huge range of different free resources out there to guide you through some of these topics, just at least either at the contracting stage when things look like they might be going wrong or when the things have gone wrong. But even just kind of getting into the policy and understanding, is there a remediation cover to kind of like step in to start negotiate some of these problems if they look like they're becoming a problem? Really, again, I'm just like giving a massive shout out to avoiding putting your head in the sand around it. What I would say is, particularly around kind of the copyright, it's difficult. It's really hard to understand. It is very, very easy just to kind of follow through with contract provisions that have been in place for a really long time that don't necessarily kind of capture a whole range of different things that are cropping up in modern day kind of copyright. So whether it's whether it's generative AI, whether it's other issues, there's a whole range of different issues that are kind of impacting really heavily around kind of copyright. So what I would say is, you're not expected to be an expert around this. You're not expected to kind of take on more obligations just because it's difficult and because you're seen as the person who is there to provide the difficult services and provide everything that's linked to tech. You really need to understand these areas to figure out, was it in your mind? Like, is this something that you really think forms a major part of the service that you're providing? And if not, to Joel's point earlier on, have that conversation up front. Equally around exiting contracts, I just can't say it enough, Joel. I'm really glad you've said it again. It's understanding how you're going to break up, having that very awkward conversation up front. I just really wanted to drive that. Like, that's a big, big issue. And also just shouting out exactly what Joel has said, compromised credentials have been a real pain for our MSP clients. The best will in the world, kind of keeping those issues protected. It often, doesn't become even a legal issue if the credentials are not compromised, if there wasn't a policy for rotating those credentials, if there isn't, you don't have good policies and procedures. It doesn't even get to a legal argument. It doesn't even involve kind of me getting to bust out any kind of savvy legal arguments. It just comes down to kind of like common sense. And often when we're defending MSPs and working with them in the face of an issue from a client that they've suffered because of compromised credentials, it just comes back to the one-on-one stuff every single time. I think 70% of the issues that we help tech providers with in terms of problems with clients, they come back to what we've talked about today. Like, I really think that if people can focus on the fundamentals, invest heavily in the fundamentals on this, the rest will follow. You'll get there.
Yeah, thanks. And just from my perspective, there's just a few things I guess I wanted to touch on. One of them is just around, I guess, the maturity of where an SME is at in terms of its growth phase. Because when you're a burgeoning sort of SME, it's all about sales and trying to just crack on and get your cash flow and everything. And I think that can sometimes be at the expense and discipline of perhaps what your risk appetite and your contract tolerances might be. So if you don't have that, or if you haven't turned your mind to it, I would recommend that an SME or a business does turn its mind to what is your risk appetite and your contract tolerance is, and try and that may change over time, and it always should be reevaluated, but try and be disciplined with that approach and stick with it, because otherwise it just opens you up for the vagaries of different contractors and different experiences, etc. And your contract relationship and your contract should always align with that risk tolerance or that contract tolerances, and where it doesn't, then you've done a calculated risk mitigation or a risk assessment and put in it might be additional insurance, or it might be additional monitoring measures, or additional resource, whatever it is to manage that additional risk. But it's important to just turn your mind to that rather than just trying to think just sales, because it's all about a sustainable business in the end. The other thing that I just wanted to touch on too was just in terms of IP, it's really important, and IP is a really complex field, and having been at both ends of where it's gone awry, I think it's really important just to make sure that you understand about, if you are developing IP, who owns that, and if it's not going to be owned by yourself, whether you can license it back so that you can, commercialize it for other clients, for instance. And if your developed IP, your pre-existing IP, make sure that you continue to own that it stays vested with yourself. So they're really key, important things, even if it's only a small part of the contract. And then the other thing I just wanted to touch on too is just around passing through that John touched on earlier, is just be careful about whether you're accepting obligations of a head contractor, particularly government, because some of those clauses can be quite onerous. They can be difficult in terms of compliance and costly, particularly in the event of a data breach, because they're passing through all the liability and responsibility down to the MSP, for instance. And then obviously your data security and cybersecurity breach notifications, etc., should reflect the APPs and ISO 27001, etc., just as a benchmark. So yeah. So I'm speaking really quickly, which I do normally speak quickly, but I just felt like I had a lot to say, so I was trying to cram it all in. The next question I have is, in terms of being prepared, what else can we impart to our members? Please, I'll pass back to you, John.
Yep. Because it's a hot topic, and again, not trying to take this into the world of cyber incident, but just the very fact that so many of the issues that we're helping MSPs with at the minute stem from privacy and cyber issues. It goes without saying, firstly, getting yourself ready for your own incident. So a lot of these, I think a lot of people on the call, you'll think of client first. You always will put the client first. That's your bid. That's your bread and butter. That's where the relationships come from. But actually just getting yourself ready for an incident on your own systems, because appreciating that your systems and clients' systems may end up being connected, and those two lines might be blurred, and you're jumping into the hot seat and helping the client. But often businesses don't prepare for what they need themselves as an SME, as a technology provider, what your business is going to go through for managing it yourself. And from that, I mean, do you have the documents? Do you have the plans? Have you tested them yourselves? Have you sat down and done a tabletop? And I don't just mean a technical tabletop. I don't mean about bringing systems offline, bringing systems online. I mean getting the entire management team around a board, around board table, around a discussion to say, okay, who's going to lead the strategy on this? Who's going to lead the communications work stream? Who are we going to lean on for the legal and regulatory support? Who are we going to help deal with all the murky work streams like the threat actor engagement, dealing with the National Office of Cybersecurity? There's more stakeholders involved in a breach than you would ever anticipate, even if you are an SME, even if you're a small provider. And very naturally, the focus is going to come on to you dealing with your client's issues if the client is also suffering issues. But what you're going to probably put second is your own response, your own needs, the impact on your staff, the impact on your business. And what we're seeing for MSPs is that the focusing on the client can often mean that there's damage done to your business. You lose your staff after it. There's fatigue. They've been working around the clock. You haven't kind of really got enough thinking as to, in the four corners of your walls, what your response is going to look like and what's important to you. I know I'm overstating that, but I don't actually think that I can, because that is the experience, that's the feedback we get from every MSP who's been through an incident. And I mean big MSPs, I mean medium MSPs, and I mean small as well. They all come back to the point of, I wish we had just rehearsed it in our own comfort. We had these hard conversations ourselves. Also, shout out to the cyber insurance policy, understanding how your policy fits in, understanding, is there a team like ours built in to support you, to guide you, to take your hand when you're going through it. And then starting to drop that down into understanding how that then integrates into the response that the clients need, your role in guiding the client through that. Another point, again, to get a little bit what was happening in the chat beforehand, Lisa and I were having a big, deep conversation around data retention. I might be stealing your thunder on this one, Lisa. Again, I'm sorry, but organizations, big, small, no matter what the industry, you're holding a lot of data. You're holding it for longer than you need to hold it. It's a problem. It really is a problem. When the incident strikes, when the issue crops up, these threat actors, they know to hunt data. They know to take a lot of data. They'll take it from your finance system, your HR system, from your client files. So they'll take it all if they can. And the lot more data you have, the longer you've kept it, the more valuable it is to the threat actors. So really just trying to de-risk, trying to figure out like, why have you been keeping that folder? Why have you been keeping that drive? Why have you been storing all this information? Is there a way that you can de-risk that? Can you take it off? Can you get rid of it? Do you need to keep it? And most importantly, even before you get to that, understanding what data you've got in your environment. They're the two hottest topics. I could keep going, Lisa, but I'll throw the mic back, so I'm sure you'll have some other points as well.
Yeah, thanks. Joel, I'm going to hand over to you.
Yeah, thanks. So as an MSP, I guess the legal side is a must and it needs to be there. But internally, from an operational maturity, the legal side needs to be more than just legal. It actually has to set out the behaviours that you agree to operate and the boundaries and when something becomes unacceptable. Yeah. From a member's perspective, if you're looking at ACS as an educational piece, looking at frameworks like ITIL, as a framework for managed IT service providers, any MSP that's looking to implement ITIL as a framework is going to ensure then you're putting in place policies and procedures for how you operate, which means you can start to map those back to your legal agreements, and you're going to start to see the gaps within those between how you operate and your legal agreement. If you can't map it, then you either don't need it or, you've got a gap. And so from a member's perspective, I'd encourage anyone to look through ACS and look at the any sort of education and implementation around ITIL as a standard to help people understand how they plan, deliver and operate in a very documented, meaningful way with controls that can be mapped back to a legal agreement. We found it critical. It does also, I'll just say, speak to one of the questions that's come through around due diligence. Our ability to be able to reference ITIL as a standard and then be able to point at our policies and procedures, overlay controls such as 27001 and others, to be able to point back to those. It gives some substance behind any due diligence that can be tracked and mapped through. Yeah.
Great.
Thanks, Leslie.
Thanks. Look, I think I was probably going to speak a little bit to the data, but John did talk to that, so I won't, duplicate that. What I would just say is that there's a lot of resources out there for SMEs just in terms of, cyber and data privacy. So the OAIC, the Cyber Security Centre. So there's a lot of resources that are, give simple and instruction and clear guidance on how incident responses and how to manage cybersecurity, etc. So I would encourage anyone that if you need that, please utilise it, because it is a front and foremost on the government's mind, and they're trying to get businesses prepared and ready in the event of threat actors, etc. So look, thanks for taking us through all those key business issues. Thanks very much, John and Joel. So the next session, we're going to be moderating, sorry, I'm just reading what I need to say. We've got some questions that we will have 3 or 4 questions, in relation to from the participants. So I think I've got a couple that have come through. And so if you've got any questions, please send them through to the chat. I'll probably I know that this finishes in about 6 minutes. So even with me speaking as quickly as I do, I might not have enough time to get through them. So what I will do is I'll just go through the first one. Thank you. It was from Dan. How do we ensure transitioning and handover to another MSP or in-house client team is included in contracts? So Joel, I might hand this one to you if that's okay.
Yeah, you may have heard me talk about disentanglement clauses before. It's different to termination clauses. Termination are very final and, about where the money's going to go and how much will be paid. Whereas getting into disentanglement is starting to look at the details of, well, what are the activities that the contract is supporting and how will each one of those activities actually be pulled out and then turned into, handed over into the new supplier. It's sort of something that I actually haven't seen a lot of, but it's certainly something that I learned about 10 years ago. And even if it's in its most simplest form, to just list out okay, this is how we do incident management. This is how we do, again, coming back to that ITIL, what are the processes that you're doing? Great. Just have a simple statement next to each one saying at a high level what the commitment is to pass that on. This will also start to flag any issues as you go through around IP ownership, because you'll start to go, well, actually, who owns the knowledge bases? Who owns the standard operating procedures? Who developed that? Come back to your IP clause, things like that. So it's a good process to go through.
And from my experience, I think it's also coming back to that scope as well. So just articulating the scope of post-termination or post-cessation of the agreement and what that looks like. And then obviously articulating any fees that might be, hourly rate, etc., that might be required in the additional services above and beyond that scope to provide that transition. I've got another one. So how do you recommend suppliers undertake their due diligence on clients during contract negotiations to manage risk exposure without putting engagement at risk? John, are you still with us? I can't see your screen, but I'm sure whether you're, I know you had we had to charge your phone before.
No, I'm here. Don't worry. Yeah, I'm definitely here, folks. Yeah, really good question. And maybe just to comment on the last point as well, survival of obligations. I think that's what Lisa's talking about there, is just making sure that every contract is going to have some sort of an obligation that typically exists. There's very few relationships that just cease and they end at that point in time. So just making sure that you've kind of thought through that. And then the principles of what I mentioned earlier on, the what, the when, the who, the how, it applies equally to those types of clauses that are going forward. In terms of the DD, it's a difficult one, right? Because people typically, when a client approaches, you want it to be warm, you want it to be fuzzy, you want it to be enticing, but you don't also want to be kind of putting 1,000 list of questions on it. I think probably Joel will talk about it a little bit more from a security standpoint, but there's basic kind of like checks that can be run against organizations to kind of understand how long they've been established. There's some really great examples out there. I think I've seen some stuff on the ACS website as well, and others around, what kind of like good procurement questionnaires look like. What I would say is that it doesn't always have to be kind of sledgehammer with a nut. So it's not, you don't have to go to that client with a very, very like long list, and typically don't do that because that will put clients off the experience of engaging with you. But just trying to zone in on, to my points earlier on, what is important to you. So if you're trying to understand like how long they're established, trying to understand, is there a credit risk associated with that? If you're trying to understand, who they are and what they do, to understand kind of the data and the types of clients that they support, asking questions around what is it the service that you're providing? What is my tangential risk to the services that you're providing? Understanding a little bit more about like their major contracts. So what is it, how do they support, how do they contract with their clients upstream, if that's what it is, because that is a type of risk that will naturally flow downhill. And really just coming back to probably just being a little more inquisitive around it. You're gonna I'll actually get the details of the person who sent that through. I'll have some more thoughts. I know there's probably some more questions, but I'll reach out to you. I've got some more ideas around that.
Thanks. I don't know whether I've got more time for more questions. I think I'm pushing the edge of the timing. So if we've got further questions, perhaps we can take those offline and see if we can respond to the participants. I really thank you for the questions. I'm sorry we didn't have much time. It was a very dense topic and a lot to cover in sort of 1 hour, as you would appreciate. So I'm going to hand back to Joel for closing. Thank you very much for the participants and the questions.
Thank you very much, Lisa, and thank you, John, as well, for participating through the panel there. That was really good. There's a number of resources we want our members to go away with this evening. The first resource is very kindly provided for members only, which is the Atmos Service Agreement Terms Checklist. I think this might help map through to one of the questions about doing due diligence. At least if you've got the checklist covered off, that's a great start. Additional resources, of course, the ACS Professional Standards Scheme webpage and the ACS Certification webpage. Also for members only, you have access to the ACS Learning and Development webpage, to the soft skills learning resources. Have a look up on some of those ITIL and cyber risk management things there, get some policy in place. So to finish tonight, we have one final poll question for you all. If you're all still available, it has just been put up at the moment. Maybe, I think that might be in the chat. Please feel free to respond. Please don't forget, we've got some upcoming events which should be coming onto a slide very soon. Chris, if we can get that put on, and a reminder that ACS is ongoing in continuing to provide wide range of events for you to enjoy virtually and in person at your local branch. And I must say, if anyone wants to come down and visit us in Tassie, come down and see us for some events. Otherwise, please also visit the ACS events page to find out more events that are coming to a branch near you or online. Thank you very much for joining us. As always, we are keen to know how well this event went. Please take a minute to complete our post-event survey via the link in the pop-up, which should be coming through now. And thanks again to the presenters, John, and also for you, Lisa, and also to the others that helped organise this event as well and make it a success. Thanks, everyone, for joining us. It's been great.
Thanks. Bye.
Cheers.
Thanks, everyone. See you soon.
Bye.
Thank you.